consent order.
Yes,
But
Your Honor.
at the moment, we understand that that will be very difficult. So, Ms. Young.
Oblige, Your Honor. Your Honors, as you rightly summarize, there has been great progress as reported by the appellants in their compliance report.
Right.
Notwithstanding the great progress, Your Honors, there are some concerns which we felt that we should highlight to Your Honors because it will require Your Honors continuing supervision of this matter. The progress and strides that have been made relate to the alternate dispute mechanism or the dispute resolution framework and the appointment of the authority. So that to date we can say yes, an authority in the person of Dean Celorio has been appointed and the parties have agreed to the dispute resolution framework.
Your Honors, I'm sorry, just to clarify, the name of the authority is Rosa Celorio,
Yes.
not Dean. Not
She's a dean of a school.
Well, she is indeed.
I'm sorry, I do apologize. I do
Associate
apologize.
So,
I do apologize.
we're talking about the same person.
Yes.
Yeah.
Oblige.
Indeed, Your Honors, yes. So we're happy to report that that has taken place. What is of great concern to the appellants, though, is that though we have an authority in place and we have the dispute resolution in place, the appellants have encountered a challenge in a recent court matter where a court in Belize dismissed one of the appellants, well, a satellite case if I may refer to it, but it concerns enforcement of the order in this matter, was that that case was dismissed because the court found that the area where the Mayan land rights case affects has not been delimited or demarcated. And in those circumstances, the court was unable to find or was unable to proceed or find that there was any trespass. What we foresee as a big challenge in relation to the authority is that the incursions, the logging permits, and various other permits, including oil exploration permits, have been issued. They have been the subject matter of complaints that have been referred to the authority. But what the appellants have encountered is the government using as a defense that the area has not been demarcated. So we foresee that the authority, though she's been appointed and though there is a framework in place to resolve, will have the same challenge. For the authority to make any determination as to an intrusion, incursion, it will have to know the physical boundaries of the land in question. So that, yes, progress has been made, but the appellants believe that they will continue to encounter problems in dealing with the enforcement of this order, and in particular, number 4 of the consent order, is that the very authority that they are to make complaints to will be handicapped in making any determination as to the complaints because of this. And if your honors will recall that even before the consent order was put before the court, there was a commitment by government in writing to demarcate the boundaries of the land affected by this consent order. And the appellants are gravely concerned that the government has not done sufficient, has not pushed for demarcation. Your honors will recall that one of the reasons given for not being able to demarcate the boundaries is lack of funding. The appellants have gone out of their way to secure funding for delimitation through the international, sorry, Your Honors, I don't have the name of the particular facility at hand. It's the International Land and Forest Tenure Facility to provide funding for the delimitation. Now, the appellants wish, and they have in the report indicated to the court that they have provided the government, the commission in particular, with the indicative analytical map showing which lands it believes will be affected by the consent order and which lands fall out of the consent order.
Sorry, who has done that?
The appellants.
Okay.
Yes, so they've provided the commission with, but they've not been able to provide the commission with digital mapping because of limited resources on the appellant's part.
Okay.
So when did they do this?
They did this just recently, Your Honors. I believe it was in October of this year.
Okay.
But please understand, Your Honor, it's not that the appellants wish to just use these sessions to rant, but the appellants must remind this court that the government had given its undertaking in writing on the 20th of April 2015, expressly agreeing or offering its commitment to develop the mechanism to provide for the demarcation and registration of all property rights that each of the Maya villages of Toledo District hold over the lands their respective residents use and occupy in accordance with the customary land tenure system. So we have an undertaking even predating the order from the government.
Ms. Young, you have a copy of what has been provided? Is that something you think that will be useful for us to look at?
The indicative map,
Yes,
Your Honors,
yes.
I don't have it with me, but we can undertake to provide Your Honors with those maps.
So that we have an idea of how that looks like.
Indeed, Your Honors.
That would be just what would we call a draft or proposed map.
Yes.
And my understanding of what you say is for you a concern is that in the same way that you say, and we don't know much about the court case, and neither would I want to go into that, but in the same way that you say that the trespass case was dismissed because I take it you're saying that there was no definitive plan or survey of the property in question. Are you saying that that is an issue that you are concerned about will affect Dean Celorio? Is that her name?
Indeed, Your Honors. You've summarized what I have tried to advance before the court, that indeed that is of concern.
But let me just understand, was there a basis for her appointment which assumed that there were Maya rights over particular lands? Would that not have been one of the bases of her appointment? In other words, what has she been appointed to do unless there is some definitive place that she would be asked to look into matters concerning those places? That's how I thought it would be, but it does not appear then from what you are saying?
Indeed, Your Honors, and one would have hoped that in terms of the government's efforts, because it all goes hand in hand, both in terms of preventing incursions into Mayan land rights in compliance with paragraph 4 of the order, the authority or the dispute resolution framework goes hand in hand with that enforcement. Unfortunately, Your Honors, it has not moved concurrently.
Well, I'm wondering, does it have to move concurrently? Because the terms of the order
Yes, Your Honor.
was that the government undertook to cease and abstain from any acts, whether by the agents of the government itself or third parties acting with its leave, acquiescence, or tolerance that might adversely affect essentially my own rights, so that even without a clearly mapped area for the operation of customary land tenure, the question is this, and perhaps government could respond to this in due course, is this not to be seen as committing to avoiding issues where there is a possibility, there's a likelihood that the Mayas might in fact claim ownership over those particular areas, so that even before we get to the issue of mapping, this seems to me to be a preliminary step which could help to resolve the difficulty that you're foreseeing. Am I right or am I wrong?
Yeah, well, that's how the appellants also interpret paragraph 4, Your Honor. Unfortunately, there are presently 2 satellite cases, one involving a government's agent, which we included in the report, and no, that isn't an agency, that's a third party, Mr. Miles, destroying a Mayan temple or lands immediately within the vicinity of a sacred Mayan temple. And the other concerns the widening and construction of a road through lands in the Halakta area, which the appellants believe is affected by this particular order, is encompassed in this order. So what the appellants find themselves is, before the dispute resolution framework was in place, it had to file 2 cases to seek to enforce and to stop government issuing permits or acquiescing to third-party trespass. And in those cases, the government mounted a defense that, well, the lands have not been properly demarcated, and therefore a court of law cannot make a determination as to the enforcement of order number 4. I can tell Your Honors that the appellants are considering their options in relation to that case.
Yes.
But just to let Your Honors know that what we foresee Dean Celorio will face is the likely defense that there is no proper delineated boundaries.
I think we follow you. And without getting into the case that you mentioned, just for our information, the issue of governments agreeing not to allow permit acquiesce in incursions which might affect the rights of the Mayas. I'm just asking, was that issue brought to the attention of the court? Was that,
Yes,
it was. Okay.
indeed, Your Honor, it was. That decision was only handed recently, and so the appellants are considering options in relation to that.
Yes.
The decision is only being brought to Your Honor's attention because we believe that it is important that this court continues to supervise the enforcement of this order because we believe and we have seen, we don't know if coincidentally, but just before these, the court date for reporting, the appellants have had the benefit of government moving faster than it usually does. So we would appreciate the continuing close supervision of the enforcement of this matter.
Yeah, with the permission of the presiding judge, can I just ask the government to respond to this precise point about the terms of the consent order? Because I think one interpretation, perhaps not the only interpretation, but one interpretation would be that the government has agreed to hold back from issuing permits and so on in areas which are claimed as areas where customary land tenure obtains. So I'm just curious about your reaction to this point that was made by Mrs. Young.
Your Honor, I just wish to bring to the court's attention that those two...
Would you mind speaking into the mic?
I do apologize. I just wish to bring to the court's
Bring
attention
it down. Yes, thank you.
that those two cases which my learned senior has brought to the court's attention addresses incursions or actions that would have been done prior to the consent order of 2015.
Oh.
Yes.
Kurt Miles was after.
Anyway.
I take that his action was in
Anyway, I
2014.
don't think we should run too far ahead because the authority up to now has not yet dealt with any complaint, as I understand it.
Your Honor, if I may, those 3 complaints that were lodged with Dr. Shelton has since been given to Dean Celorio, and she is actually reviewing those complaints now.
How has she gotten those complaints?
Yes, Your Honor.
How?
Oh, she received them by email from the Solicitor General, and I am made aware, based on the report, that the appellant had also shared the complaints with Dean Celorio, as well as the Commission had shared those complaints.
Okay, so these complaints were made by the Mayan,
Yes, Your Honor.
and they were sent to whom?
They have not been sent to any government official, but they were sent to
Somebody
Dr.
must
Shelton initially. Initially, they would have been sent directly to Dr. Shelton. That's my understanding.
directly?
That's my understanding.
Okay.
Initially.
Not through any clerk.
No. Cloud?
A clerk.
No, Your Honor. No, Your
Okay.
Honor.
Anyway, so she has seen a few complaints. She is considering those complaints.
Yes, Your Honor.
Okay. But as far as the issue that was mentioned is concerned, can never be the defense in any case that the land has not been delineated, because if that is the case, then there can never be an issue. So in general, that could not be a defense. It could be a defense in a certain particular case. I also mentioned that, as is often said, it is very difficult to draw the line. Where is the line to be drawn? But it is much easier to say on which side of the line the case is. So that is a second remark. And a third remark is this is a court case. We don't go into that. But of course, a court of law is a different kind of mechanism than a dispute settlement arrangement, where, of course, there's much more freedom for the authority to say, well, this seems to me an area which is clearly within any demarcation. So I don't think we should go ahead too fast and see this as a danger for a total failure of the procedure. So going back to the more nitty-gritty question, according to the framework, the government would provide an email address and would see to it that a clerk would be appointed to collect the complaints. Now that is something which was decided, which was promised in August 2018. I don't think it has to take that much time to make an email address or to ask a clerk of the Magistrates Court or the High Court in Punta Gorda to take this job going to be a full-time job anyway. So what about that?
Your Honor, we still have not established an email address for complaints to be lodged for the authority, but that is something that's in the process of being finalized. As it relates to the
That is in the
establishment.
process of being finalized.
Yes, Your Honors.
But this is in the process of being finalized for more than a year now. So
I do acknowledge that, Your Honors. However, in light of the recent appointment of Dean Solo, she does have some concerns, and we have not been able to fully address all those concerns
what are
as yet.
her
Well,
concerns?
it's more in relation to the process. What is it that she's doing now? She's actually going through how it is that you lodge a complaint, and she's also going through the complaint form itself. So until she's able to complete that revision, then she can give her feedback, and then we can proceed and have something concrete.
To whom is that feedback will that be given?
Your Honors, I believe that it will be shared with the Solicitor General, and then that can be shared as well with the appellants.
I would
for
think
their.
so,
Yes,
yeah,
Your Honors.
that-
Yes, Your Honors.
They are part of this. Huh?
Yes, Your Honors.
Okay.
Give us a time frame within which the email will be established, please.
Your Honors, if I may.
Would you require some technical assistance? Because that could be provided.
Your Honors, we do have a Central Information Technology Office, and they are the ones who are responsible for any government-issued emails. So to say, a time span, I cannot say.
Anyway, Ms. Young, you succeeded in getting some complaints to the authority. So how did you do that?
Yes, as soon as the appellants were informed, I think it was Dean Celoria herself and not the respondent of her appointment, the appellants then forwarded the complaints that it had earlier lodged with Dr. Shelton.
Okay.
You forward them to the dean?
Yes,
At what email address?
at her
Her work?
work address, yes.
Just one last thing only one small thing on her appointment. Did she receive a written document appointing her?
Yes, Your Honor, there is a contract that was entered between
Is that
the
something
government.
that can be made available to us?
I don't see that being an issue being disclosed to the court.
So going forward then, until, Mrs. Young,
Yes, Your
until
Honor.
the government has established this email address, I assume that you could do what you've done before. You could simply send the comments, the complaints to the dean, and I imagine you would copy to the commission, and if a government department is implicated, you'd also copy the government department. How does that sound?
Yes, indeed, Your Honors. I think my instructions are that Dean Celorio has indicated that she's presently working on her procedure and will be informing the parties. And after that, after she's informed the parties, then the appellants will be lodging directly with her.
Yes, and copied in the way I suggested, please.
Yes, of course, Your
And
Honors.
did she give
the other
any
side.
indication when she would finish this work?
No, Your Honor, as you can appreciate, she was only appointed in October of
understand.
this year. So I don't think she's given a time. She's not indicated to the appellants. I don't know if she's indicated to the respondents as to when she would have completed her procedure.
Is she going to do that in draft and then send it to the parties? Is that what you expect?
Yes, Your Honor, that's what I expect will happen.
It wouldn't be a fait accompli then. She will have it in draft, you will make comments, and then she will finalize.
Yes, I think that's what the parties are expecting, Your Honors. Your Honor.
Yeah, could I take you back to the court proceedings? And again, not intending to get involved in that at all. But there is a provision in the framework, and I'm looking particularly at paragraph 18, which allows the court to refer for review or mediation by the authority complaints, essentially. And paragraph 19 does something similar in relation to the Attorney General. Now, the question is whether in dealing with these satellite litigations, this provision might not be useful to bring to the attention of the court. Of course, ultimately it's for the court to decide whether it wishes to submit for review, yeah. But I would have thought that that might be a useful provision to bring to the attention of the court because it has the consent both of the appellants and of the government. And beyond that, the question is whether some kind of education or sensitization campaign might not be appropriate to bring this provision to the attention of the judiciary, generally speaking.
Indeed, Your Honors, I think that was remiss of the parties in those two cases to have brought to the court's attention. And we will endeavor to do so. One, we are awaiting a decision. Matter has been tried, so we will definitely bring it to the judge's attention of paragraphs 18 and 19.
Yes.
That is available to the court. Grateful for your pointing that out, Your Honor.
Of course, we have to point out that since 2015, we have had many compliance sessions, and at every session it was made clear that this particular point is of the utmost urgency. Now, we cannot keep saying it's urgent, and in the end, still nothing has come off the ground. We understand that efforts have been made, but it is really time now to have something functioning. And I do think that we have been very patient, and we will be very patient in all the other fields which take even more time and are of greater complexity. But this is really not so difficult to do. So we urge, I think, the government to really get this thing done. One of the issues was also that the authority needs to get some support, needs to get some finances, I suppose, funding. There was something in the framework about the remuneration. Is there anything decided about remuneration?
Your Honor, all those are covered under the contract, and we are in discussion with the authority because based on what she has indicated, she does plan to visit in certain cases, I believe, Belize, and she will be required to be accommodated. And as such, those are part of the terms of her arrangement as being the authority.
Now, okay, so Christmas is considered by many a light and happy occasion. Could we expect something before Christmas? I don't think that it should be too difficult to get something out. At least if we know that everything is ready to go before Christmas, then we can wait till the next year, but January, to see it functioning. That would be a good Christmas present, wouldn't it be?
I agree, Your Honor.
This is not just a present, because this is a matter of really an obligation that follows
Yes, Your Honor.
from the orders. But really, we do think that time has come, that time is now of the essence, and that we cannot keep dragging our feet with all kinds of issues. We think that the issues that still remain can be solved within a reasonable time, and we would be very happy to see some report from both of you before the Christmas recess.
Yes, Your Honor, we are guided.
Can I also ask whether the parties have considered whether the role of the authority will be put into some legislative ground so that it's not simply based on a document which has been signed by the parties, but it is in fact the law of Belize. Has that been given thought?
Your Honors, I am advised that that is something that is being considered to be included in the laws that will govern
The legislative
yes,
framework
yes,
that is to
yes.
disobey. And
Because one of the powers that authority must have is, okay, if there is some complaint about some permit or whatever given by some department, but you can contact that department.
Yes, yes, Your Honor.
You know, quite informal, but hey, can you tell me what's happening here? Maybe there's a misunderstanding. That's good to know too. If not, that she will get answers to the questions in writing, and that it will be given to both sides, and to take it from there. Things like that. Very simple.
Yes, Your Honor, and that is something that she has highlighted that she would like to be done, that there be a focal point that she can go to, I believe, both from the perspective of the appellant as well as the respondent, that she can contact that person and they will be able to provide whatever information she needs.
Correct. Okay, and that she, that you can, whatever she does, she will stay within the framework.
Yes.
But that she can have a pretty active role, and is not sitting back in the traditional adversarial style. Practical. That's the best way to go forward with this. And she also understands, we all understand that whatever she decides or to whatever decision she comes, that it can be followed if there is consent, but it's not something you can enforce, but at least in many cases you don't really have to officially enforce things, because a lot of decisions will be followed, probably. And if not, you can always use the material if it can be used according to the law of evidence in a court of law, if you want to go that far. But the whole idea is that not for every accident or incident the Mayas have to go to court, which costs money, which is expensive, which takes time, etc. So to be clear about what this is supposed to be. So,
Yes.
Yes,
We cut Mrs. Young across. We're with the authority, and then we diverted to the government. So.
indeed, Your Honor. So, Your Lordships, Your Honors have inquired about the legislative framework and what is to inform the legislative framework, which my learned friend spoke to, is the Maya customary land rights policy. My instructions are that the appellants have, since the 4th of February of this year, submitted the policy for the Attorney General's review and has not gotten a feedback as yet, so that before any legal framework can be put in place, the government has to sign off on that policy. And so one of the outstanding items from the government is the signing off on that policy, Your Honors. So we would...
That is not particular to this authority.
No. The dispute framework, that's
broader
separate. Yes, that has more, yes, indeed.
Can you give us some idea as to what is to be included in that customary land policy?
Your Honors, I believe that
Just the highlights.
All right. Crave the court's indulgence.
But then we have this the feedback from another feedback from if then it's ambulance.
Yeah, that's why it's only 2 only. We done with it because remember we submitted the report on this done.
All right.
Maya
Okay. All right.
Okay, just before you, so I think we concluded the part for the authority. It's very clear what the court would want to see to get progress in that area. So what we're now going to deal is with the other issues, which are larger even than this point. And so I will invite you to say, well, according to the report that you have filed on those issues that we're now going to discuss, there is some satisfaction that there is some progress, but it can always be better, of course. But you can deal with this issue. Also, certainly we will also ask the chair lady of the commission, who will be very well known with those facts, to speak. But you can make your points first.
Yes, guided, Your Honor. So one of those issues which the appellants wish to have some feedback is the Maya customary land rights policy, which would inform the legislative framework. My instructions are that the policy and the intended legislative framework would really seek to codify what the courts have recognized as Maya customary land tenure rights and provide mechanisms to protect those rights. So it's in general to seek to codify those rights as defined by the courts throughout this litigation process. In terms of there's also outstanding, Your Honors,
What is the state of this Maya customary land rights policy? That it is, the Commission has committed to continue the dialogue if there are any substantial changes proposed before it is advanced to Cabinet. I see the Commission gave its undertaking to write the Prime Minister to inquire about this policy. So that is the last thing you know?
Yes, that is the last, and it's been with the government since the 4th of February 2019. Yes.
Should we ask this chair lady now?
We would be most grateful,
Yes.
Your Honors.
The matter with the land policy, the Commission is satisfied with the land policy.
Okay.
And we have submitted it to the Attorney General's Ministry for their review, because our terms of reference is just that we make recommendations to the ministry, who then forwards it, either sends it back to us to further review and discuss with the Maya. And that was submitted, I don't know if it was in February, but I don't know offhand when that was submitted to officially. The Commission has submitted it to the Attorney General, and we await their feedback on whether it's something that they consider ready to be taken forward to Cabinet, or will be sent back to us with proposed changes and further discussions with the Maya.
Just tell us then, when did it go to the Attorney General? And if you could just give us very, very briefly, in probably 2 to 3 points, the main aspects of the policy.
Really, the main aspect of it talks about the context under which all of these Maya lands and rights will consider, what the UN Declaration on the Rights of Indigenous People, different international obligations that Belize has, and then it goes into how we're going to be addressing third parties. I have it right here, Your Honors, and I think I submitted a draft to the courts a while back in the last report, like a draft. If I didn't submit it, they had submitted it to you. So this is just at a very macro level. This is what we're going to do. This is how this is going to be situated in the context. It doesn't go into detail enough to say that it's detailed enough to say what will be included in the legislation, because we have decided that we will do it together with legislative principles, and that is something that what we foresee will happen is that eventually there will be a Maya law, Maya Lands Act, something separate that will take into account all these matters, like the dispute resolution framework, how are we going to deal with disputes later on, because whether we do it, you know, legislatively, I imagine that that is something that, so we're going to be looking at even the alcalde system, are we going, because there was a draft alcalde act that is like 12 years old, and are we going to then revisit that and incorporate it in the overall Maya lands act or the Maya laws, whatever you want to, because we have agreed in the discussion that instead of just amending existing legislation, that it would be more efficient to create a parent act. So that's where we are with it. But in the meantime, I think the government has had some capacity building whereby we brought Ms. Diana Shelton and other indigenous peoples experts to dialogue and to raise awareness about indigenous peoples' rights and within the UN Declaration on the Rights of Indigenous People. So we are working on it so that we kind of sensitize them about how this whole, where this consent order sits in Belize and where it sits at an international level.
Now, this document went to the cabinet or?
No.
To the Attorney General? Attorney General?
Yes.
Suppose they say, well, we agree. Suppose. What's the next step?
Then the next step would be that you write a white paper and you submit it to cabinet.
Okay.
And then cabinet reviews it. Either they accept it or they send it back with proposed changes. And either the Attorney General, what we're hoping is that the Attorney General would then inform us that we need to go back to dialogue with Maya so that these changes that are being proposed, and we continue the discussion then.
Yeah.
So I think what we're trying to eliminate is for it to go to cabinet and keep coming back from cabinet, that when it goes there, at least at the political level, at the technical level, within the Attorney General's ministry and other ministries that we have engaged, that they would have given us their feedback, because we don't want them to bring objections when it's already at cabinet.
Yeah.
So we have engaged the Ministry of Rural Development and Local Government. We have engaged the Lands Department, the Commissioner, the Registrar of Lands. We've engaged forestry and fisheries, like those key ministries that really affect natural resources and land. I mean, it's something that we have shared the drafts with all the CEOs so that all ministries have had the benefit and the opportunity to give us feedback, and that was done even before we
part of this is also the free and prior informed consent policy, or is it a separate?
No, the way we agreed that we would do it and is outlined in the agreement of December 2018, that we would develop with the Mayas the free, prior, and informed consent. And so with the assistance of the expert Fergus McKay, we use the Mayas consultation framework as a resource document, and a majority of what they had in there was taken into consideration, and we developed the Belize free, prior, and informed consent as it relates to the Mayas in Toledo. Now that was sent to them, perhaps I would say a draft was sent to them maybe, I'll be conservative in saying 4 months, but I think it's been longer than that, and we have not gotten any response from the Maya as today.
They have reported that steering committee meetings have been held and were finally completed on the 12th and 13th of October, correct, this year? And the feedback is now being compiled and will be sent to the Commission. Any idea how long that is going to take?
Your Honors, my instructions are they're aiming to do so within the next couple of weeks.
Within the next couple of weeks?
Yes.
Okay. Not a Christmas present.
Yeah, they have been very clear in saying that their process of engaging their communities and their leaders is a very lengthy and very slow process.
Yeah.
So we just wait for them once we send it forward, and then our process eventually slows down when we send it to government. So the process for it to go through the various channels is what it is really. And then we have the other one that is important is the delimitation methodology, which again we submitted again conservatively 4 or 5 months ago. And we just got response through the mediator, because now we have a mediator. And the mediator that they are satisfied, or that they're going to send us their the delimitation methodology. We are looking at it now to see what changes they have proposed in it, and go back and forth with that. So
I just wanted to ask you about the policy that is now with the Attorney General. And you said that's on a macro level, you say. And then subsequent to that, there's a white paper. I saw in one of the reports that a consultant, Gordon Bennett, had been identified.
Yes.
To do the legislative drafting.
Right.
Is he to await the approval of the white paper before he starts? What is happening with that?
no, we're going to proceed with drafting.
So the drafting, you say there should be a sort of parent act.
Yes.
And there are other acts that you are proposing?
We don't know exactly, based on when Gordon comes, he will advise us whether we can capture all the different matters of concern within a parent act, or whether we need to address develop separate acts, or do we need to just amend existing legislation. What we are thinking is, for efficiency and clarity, that we would want to put as much as possible within that parent act, instead of having people going all over the place, because this is a whole new area for government and judiciary and everything, and we want to be efficient in that. So whether there will be other legislation, bigger legislation, we don't know, and I think that is also a conversation that has to be had with the Maya people. For example, with the Alcalde Act, that is a whole separate act as presently drafted, but is that still applicable, or do they want to incorporate that into the Parent Act?
Okay, Ms. Young.
Yes, Your Honor.
So several issues there. We haven't spoken about the funding yet, but that will come.
Mm-hmm.
So we talk now about the Maya customary land rights policy. You heard what was said about that. Prior and informed consent policy will be part of that somehow. There's also the third-party interests. Now, in the report that you sent us, you expressed some satisfaction about at least that there is progress. Everybody knows that goes very slowly. One of the reasons, and it is a complex process, one of the reasons why the court decided kindly unique to have this monitoring process.
Mm-hmm.
So is there anything you would want us to say about those issues?
Your Honor, we would want to credit the court's supervision for the progress that has been made thus far. It is true that for the appellants, the consultative process within the communities can take some time because of translation issues. We're dealing with Maya communities and Kekche communities, and also because of the distance between the villages. And So because of that, that has taken, but for the most part, the appellants have been ready and willing to move this process because it is in their interest. But we believe that the court's close supervision has provided impetus to the government in the steps and progress that have been made thus far. So we would appreciate if the court were to continue its close supervision of this matter because we are now seeing results. We are seeing a government that is now more engaged as a result of the supervision, Your Honor. So I think we've said enough in terms of the progress that has been made and the foreseeable challenges. So yes, we would just, and we want to thank the court as well for the time and effort spent in its supervision. And of course, Your Honors, for hearing this report session in Belize. The appellants have been litigating this matter for in excess of 12 years and have not seen any tangible results. And so hearing directly from the courts, the appellants in attendance, adds credibility to this process. So we are grateful for the report session being held in Belize.
Yes, we hear you, Mrs. Young, but did you want to respond to anything that was said by the chairperson of the commission?
Yes, yes,
one
Your
of the
Honors.
things that she mentioned was that basically she has been waiting for 4 months to hear back from you. We understand the process of consultation takes time,
Yes,
but you have promised to let the commission have the views of the Mayas within 2 weeks or so on the free prior informed consent draft.
indeed.
But there was another exercise I think she's also waiting you on, that, and you started with that earlier,
Which
the
one?
mapping exercise.
No, we have provided.
You have provided?
Yes, the indicative, I think, analytical maps. We have provided that to, the appellants have provided that to the
Sorry,
respondents.
thank you. Did I misunderstand something you
Yes,
said? Yes.
there's the free prior informed consent, and there's the delimitation methodology, which really outlines in detail how we're going to go about identifying the lands, which we have agreed that they will lead the process,
Yes.
and that government will go in to for verification purposes, so to make it more efficient. So that is the delimitation, which just last week or just a couple of days they responded to, but that was after like 5 or 6 months.
So they have now responded?
Yes, and what they're talking about, the indicative map,
Yes.
just to say when it's sent to you, the purpose of that indicative map is solely for us to start working in identifying third parties, for us to be doing our inventory of who has land holdings in the area. And that area is approximately 2 million acres of land.
A bit bigger than Barbados, I think.
Huh?
I'm not sure it's probably bigger than Barbados, but I'm not sure. I shouldn't say that.
So based on that indicative map, which, you know, includes some protected areas, so those are easily dealt with, but the other areas, and then when we also told them that if there are villages in the Stand Creek district where Maya customary land tenure practices exist, then it would be best for them to bring that forward at this time instead of bringing it later on. So they
Yes.
have given us, we provided them with the map, the official map, and they drew a line around it, you know, I'm saying more or less, this is, well, I don't know how.
But that's
Gives
different.
us an idea,
That's
a beginning
different.
point.
That's different from the methodology. The indicative map is
Yes.
different from the methodology.
Well, that's the phase one.
Phase
of
one, yeah.
saying,
Yeah.
okay,
This is
based
where we
on
start.
what our information is and our knowledge of the Maya villages, this is where our lands lie, and therefore, government, you need to start doing your inventory for lands within this area.
Got you.
Yes, so-
Yes, sorry, go ahead.
No, thank you, Jen. So that, from what I understand then, the process that you're going into will not just cover the lands in the Toledo district, but in Stan Creek as well?
Part, just they only have one village. We were advised that, look, either you deal with it now or you're gonna deal with it later, right? So we invited them to say, well, if there are other Mayan villages, because they don't all lie in Toledo district, that if there are other Maya villages that practice customary land tenure and hold their land customarily, then it's best that you address them. So based on that, they provided us with the outer delimitations of one Maya village in Toledo, in Stan Creek.
Outer delimitation, outer means that they themselves do the work?
No, outer means just a sketch
the outside.
that's outside, like just the perimeter.
Yeah.
I see.
But they did it. We weren't involved in that process.
Now that project, as I understand it, depends on the funding, correct? Heavily. And well, both sides have come together and have filed a petition or a proposal with the International Land and Forest Tenure Facility, as I understand it.
Yes.
And we are now waiting for, although there seems to be some optimism, but we're waiting now for the final decision of that facility, correct?
Well, yes, that, can I?
Yeah, you can, and that is your,
All right. Well, that was a donor that we identified,
okay.
that the government identified, and then based on the dialogue that we had with that donor explained to us that only an indigenous people's organization can be the direct recipient of their monies, but that there are mechanisms that facilitate for government activities to be funded, because their premise is that they don't want to invest money in a country where the government shows no commitment to resolving the matter. They want some returns on their investment, because what they want is protection of forests.
Okay.
Right? So the submission, the official submission goes from, they're using the Holy and Trust Society to submit to the land tenure facility, and it's a concept that was drafted in consultation with us. For us, it's very clear what we need money for based on the December 2018 agreement. And so we just put in a budget and said, these are the kinds of money that we want, and government is going to put in its share based on what our present budget allows.
Okay.
And so that was submitted, and I think they submitted for more than $2 million US, but my understanding is that the donor is only committed to $1.2 million. And so we're waiting for feedback from at least the last communication we got from the Maya is that they're in dialogue with them. Like I said, we don't dialogue directly anymore with the land tenure facility about the details of that.
Okay, thank you. Ms. Young.
Yes, obliged, Your Honor. In relation to the International Land and Forest Tenure Facility, Your Honors, my understanding is that this facility basically funds non-governmental organizations. And in other countries, such as Nepal and Peru, what it does, it matches government funding. And so my instructions are this facility wants to see that government is committed, and the commitment has to be in the form of matching funding in terms of moving forward. In terms of the funding being provided to the Maya, the MLA and the TLA, that's a preparatory grant that has been approved for them. But in terms of the larger scope of works, the facility is hoping that government will provide matching funding, and that it will not be asked to fund the entire exercise. As Your Honors can appreciate, when the government gave its commitment was not to source funding. It committed directly to demarcate. And it was the appellants who reached out to the facility and with a view to secure funding, given indication from the respondents that one of the challenges they were facing was funding. So we just wish to correct that aspect. And the auto delimitation, Your Honors, I don't want this court to feel that the appellants have not responded. So for the record, we wish to correct and invite the court to read paragraph 17 of the report, where the appellants had submitted the delimitation policy to the commission on the 8th of July of this year, and has gotten the commission's feedback on the 23rd of October of this year. So that it is not something that is outstanding in terms of for the appellant's part, Your Honors. They have provided that to the commission and have just now gotten that feedback. So we just wish to correct that for the record. I don't know if there are any other issues the court wishes to address.
I wanted to ask a specific question about the customary land tenure policy. Does it include mineral rights?
My instructions is that it provides, it encompasses generally the rights recognized by the court, and also provides for protection of those rights in relation to third-party rights. But, Your Honors, I have the persons from the Maya Leaders Alliance who are here in court that could explain better to this court what that policy in fact says. So if your lordship wishes to hear from one of the leaders, they could more particularly outline what that policy encompasses.
This is just a general question to counsel here. Just 1 second.
Yeah.
Because you're saying that you have a document now with the Attorney General,
Right.
and you're waiting to hear back from him. And I'm just curious as to whether that document also covers that subject. Does not.
What it does is these broad definitions that we have, and I'm just going to quickly read them. For our purposes in Belize, using international standards and applying them here is what are we referring to when we talk about indigenous peoples, Maya people, members and memberships in the villages, Maya lands and territory in Belize. So we've agreed on what those are, customary laws and practices, and then Maya customary land tenure system, what does it refer to? To be clear so that we're on the same page, what do we mean by delimitation? Because we had a whole
I can imagine.
discussion about what is delimitation versus demarcation versus surveying an area. And demarcation, then what is the expectation with registration and titling, capacity building, self-determination, making sure we had that clear definition. What are we looking at for free, prior, and informed consent? But it doesn't go into detail because based on the advice that we got from Mr. Fergus McKay, these things are like, they're so in-depth that it's better. So we're doing them in these pieces. So FPIC, that's a process. Delimitation, that's a whole other document. And so we envision that there will be various documents and dialogues specific to that. So then it also goes into what are third parties, traditional knowledge. Some of them are obvious, and then what are the policies, what are the guiding principles under which this policy will which our work exists, good faith, transparency, partnership or collaboration among stakeholders, and public participation.
Yeah, you said you have already, but if you don't mind sending the document again to the registry, that would be very helpful. So the general law then relating to the vesting of mineral rights, I assume that will continue to apply, do we know?
I cannot say, Your Honor, I cannot say for certain that will prevail, but as it is, that is the status quo now.
That's the law at the moment.
Yes,
right?
yes.
Okay.
Ms. Young,
Sorry, Your
Ms.
Honor.
Young, any other channels for funding that are being
Any other channels for funding other than a facility?
Impact was mentioned at some point.
The- Okay, yes, yes, Your Honors. In terms of the third-party rights, there is funding from the Red Plus at paragraph 21 of the appellant's report. And that project is to assist in creating an inventory of third-party rights.
so that is the estimated 200,000 US.
Yes.
And was there some reference to impact?
Want to know what reference? Other third-party funding, such as but you have the appellant's hand. Yes. Your Honors, we would need to consult with the Maya Leaders Alliance to the best of the information that we have been presented with. We're not aware that they have reached out to Impact, but again, Your Honors, we wish to say that we would need to get instructions as to whether there has been without our information. Speaking for the appellants. Sir, ask her.
And so could the commission, of course.
Yeah, the way the Lantana facility looks at it's co-financing. So what we have to do is to demonstrate government is contributing money. So it is, what is it? And so we have done that budget to submit to government, and I think it's over like $1 million towards the project. So I don't know if there's clarity on what they mean. I think they call it, I know it's co-financing, and I think, so yeah, that has been, I forgot what word they, matching
funds.
funds.
The chairman was talking about impacts. Is that what you're talking about?
No, I'm talking about I don't have any knowledge because they were the ones who were supposed to follow up with impact.
Okay. But as the chairman said, you could as well. So, you know.
Well, I think we reached out to them one time and they said they didn't have any money.
Okay. Well.
So,
Not much of an impact then.
and that was a long time ago, so I don't figure things have gotten any better since.
Okay, I think we have been informed sufficiently. To make one thing clear, of course, this court will keep following this tenaciously. The supervision is only done when the project will be established, because it's nice to have declarations of law from the court, what the law should be, but justice can only be achieved once that is practically done. And so we will try to follow this and to guide this process till the very end. What we suggest is, as we have expressed, that we really would want to see everything done to have this authority and this dispute settlement arrangement off the ground. So we would like both parties to report on that point before the 15th, on or before the 15th of December. We put some pressure here, but I think that enough time has passed to justify that. So we want to have a report, and we want actually to see a very positive result reported on the 15th of December. Once we have that, we will then decide when we will have the next compliance hearing. So we look first at what you reported us to decide when exactly we want to gather again. I think those issues that some of those that have come to the fore, like the broad policy that is now by the Attorney General, maybe at some later stage when it is more concrete, that we would want to have even more information about that. I think for the time being it's fine. So we want to report especially about the dispute settlement arrangement. But if there are other matters that you can report us about, then of course we would like to see that also in that report from both sides. But especially I'm looking at the government side to have it done. So that's it. Thank you very much. And we'll stand adjourned.
Much obliged.